Good, good. I sent Bill a message and hopefully he'll be joining us here. He had a busy day, I think. Um, so we're letting people filter in here. King, I meant to tell you, we've had some recurring complaints that there's no anecdote forthcoming at the end of these from you. That you've gotten the people used to it, King. They
Well,
have expectations.
they're all they just outed themselves as late comers. They're the kind of people who come in and sit in the back rows 10 minutes late because my anecdote started the session last time.
That's what I told the one person. So, well, you're just taking your place in the pantheon of Southern raconteurs, I think, is what's happening here. So you're going to have to store up a whole, laundry list of stories to tell.
I'll have to pull out my old moth-eaten books and notebooks and memos and
Right.
whatnot.
Well, I do think we're the only podcast going, well, not podcast, but Spaces thing here going that was talking about Tennessee Williams with relation to the case in Georgia. So, you guys are getting an elevated level of discourse on this channel. There's Ship. Hey, Ship. I'm going to send you the invitation. So stand by for that. Okay. All right. So while Ship is getting logged in, I think he can hear us. So I'm gonna start with the topics tonight. We want to talk about two things. One is the Supreme Court ruling today, which is there's no words to it. There's no meat to it. It was just on the orders list, dealing with Meadows's um, petition for cert concerning his removal case. And then the other topic I wanted to cover is the move today in New York, where the judge there punted basically Trump's New York case for a week. So we're going to cover both of those. But before we get to that, Ship, you had a busy day today, I think. Can you tell us briefly what was going on? Or
Yes, Steve Baker, the journalist for Blaze Media, who has been covering J6 cases from the beginning. In fact, sat through every day of the first Oathkeeper trial of the main Oathkeeper leadership defendants, and oddly enough was the only journalist that I saw in watching the coverage online who actually reported on cross-examination rather than simply closing their laptops when the direct examination concluded. Steve was
and as anyone who
charged.
sat through trials knows that a lot of the wow part of trials occurs during the cross, not during the direct testimony.
Yeah, the direct, and particularly in the Oathkeeper cases and most other January 6th cases, the direct is practically from a script. It's been rehearsed. The questions and answers have been rehearsed so many times. And now, I mean, not surprisingly, the government has a responsibility for building its case and going in prepared from the moment, the first witness is called to have all of its, evidence marshaled and lined up and ready to go. That's the job. So, but the exploring the strengths and weaknesses of the government's evidence on cross is, where most of the action happens in our trial. And I mean, the same thing happens when defense lawyers or when defense witnesses start to take the stand, including sometimes the defendant. Prosecutors don't really get to do a lot of that, but that's where fireworks can also take place. So Steve has been covering January 6 cases for quite some time. He was originally just freelance, and he would sell video, audio, stories. He published. He had a Facebook following for many, many years. He'd covered lots of different kinds of political protests, and self-avowed, and on his Facebook page, libertarian. His it's
Woohoo!
I mean, you can go back. I forget the acronym he uses, but it's the Constitutional Libertarian or something like that. Um, but um, so he came to the protest to cover the protest, and was not a Trump supporter. Did not vote for Trump. Did not vote for Trump in 2016. Did not vote for Trump in 2020. Um, and he came to the Capitol that day with using an iPhone, but he wasn't just some Yahoo in the crowd, holding his iPhone up over his head, taking pictures of everything he saw. He had a microphone, he had a tripod, he had two battery packs so that he could run continuously without having to turn the phone off and on, and taped for about 7 hours, some of it continuously for long periods of time. He went
See,
inside.
that sounds an awful lot like journalism to me.
Exactly. And when you watch the video, it looks an awful like journalism too, because just in watching his mannerisms, he is kind of at various times doing like a 180, covering all the events around him in a panoramic fashion, and he's moving slowly. He's by himself nearly the entire time. He was with a friend outside, but then when he went inside, he's by himself, moving slowly and methodically and pausing for long periods of time at various places inside the Capitol, just capturing the events and speaking to Capitol police officers, asking questions and getting answers back. And in some instances, asking questions of members of the crowd. So, what sort of again like journalism. But he made some comments on his podcast that night, watching news coverage, and his comments expressed a certain hostility towards the party in control of the Congress, the Democrats, and one thing he said that caught the government's attention and was repeated to him today in court was that he said in an interview, and this interview lasted 15 minutes. It was WUSA 9 here in DC.
Yeah.
He did a recorded interview with one of their hosts in studio. The interview lasted 15 minutes, and they played about 40 seconds of the interview on air. And among the things he said was, I agree 100% with what happened today. Well, within the context of a 15-minute interview, that comment can have a lot of meanings. And the context of the comment was about, from a libertarian perspective, an element of the population other than the left wingers taking on the government and saying we've had enough.
Right.
Basically, he saw it now spreading across the political spectrum from left to right. Unhappiness and dissatisfaction with the conduct of government, which for libertarians is like a unifying rallying cry.
Right. Yeah. Right. The libertarians often describe themselves, me included, as we're the people where the left and the right kind of meet up.
Exactly.
On the other end of the circle,
Right. If you describe the political spectrum of the circle, libertarians is where the two ends meet.
Right.
So Steve is interviewed because his video starts appearing in various outlets. He sells it to the New York Times. He sells it. It was in the HBO documentary, and gets the government's attention because he begins covering January 6th cases in a critical fashion, critical of the DOJ narrative of the events of the day, and comes to their attention for that reason. He has covered January 6th events in the courthouse pretty much from the start.
And just so people know who aren't local from here, you said WUSA 9. That's the local CBS station. So it's not like he's on some, alternative broadcasting shortwave radio. No, WUS 9 is CBS.
Right. And what had happened is he was, so I know the events here, and I know we're getting far afield. I'll only take a minute or two more.
Yeah, go ahead.
What had happened was he came out of the Capitol building. This is in the middle of the afternoon. The events are still going on. And he sees, local news crews are starting to show up because they want to capture what's going on. They weren't there right at the outset, but as the events of the day begin to play out and some live coverage from CNN and other outlets starts to hit the network, the local channels rush their news crews into the field to see what's going on. Well, Steve is sort of standing in a media area. There's lots of cameras around, lots of media gathering in this particular location, and Steve's there. And he hears a couple of reporters talking about, well, there's information that somebody got shot. And Steve says, yeah, I was, I was right there next to where it happened. And in fact, I got it on video. You want to see? And not the actual shooting itself. But so these reporters who hadn't been inside, they just, oh, yeah, we want to see it. So they look at his video and he starts to tell them what happened. They said, will you go on air? Steve says, sure. So they set up they do this 15-minute recorded interview that they then use bits of through the course of the day. So, I mean, all of that sounds like journalism. But some of his comments at various times expressed a point of view. And
oh, come on. Journalists expressing a point of view? Yeah, that's unheard of. That's unheard of.
So after looking at Steve for a period of 2.5 years, the government finally decided to charge him with 4 misdemeanors. And that charging decision, oddly enough, came after Steve had written 5 very critical articles of the Capitol Police and the FBI and their performance on the day. And those articles involve some of the early work, some of the groundbreaking work shared by others. He wasn't the only one, but he was among them. The pipe bomb issues. Steve was in early with reviewing the video with Congressional Oversight Committee, along with Darren Beatty at Revolver News, and Julie Kelly was also given early access to some of the video, and Steve was another person given early access to the video, and they found the video of the supposed planting of the pipe bombs and the nonchalant response by the Secret Service to pipe bombs in the general vicinity of the vice president. There's this whole rabbit hole you can go down on the pipe bomb issue. He also uncovered and has fairly well documented in ways that are going to turn up in appeals what seems to be perjured testimony in connection with the Oath Keepers case, where Harry Dunn, I think it's Harry Dunn, one of the main government witnesses about this standoff with the Oath Keepers, where Harry Dunn is by himself and he's confronting a line of 5 or 6 Oath Keepers. And the problem is Harry changed his story 3 or 4 times. There are 3 or 4 versions of that
when witnesses event. Do that, don't you?
Yeah. So the government needed somebody to corroborate the best version of the events, which is what they were going with at trial, notwithstanding these 3 other versions of events that Harry had given. And so they had mysteriously out of nowhere, miraculously, I should say, out of nowhere, David Lazarus, Capitol Police Officer Lieutenant. Oh, yeah, I came up the stairway and witnessed the confrontation between Harry Dunn and a bunch of people in military regalia. And yeah, that picture that you're showing me, that is the scene that I came upon. And I guess if those are the Oath Keepers, then yeah, they were the Oath Keepers.
So trying to corroborate and buttress this witness who's
exactly
problematic.
Because Harry's testimony stands on its own, and he's told more than one version of the story. So now you have this supporting, corroborating testimony. The only problem is, at the moment of the confrontation, which was established by body-worn cameras in the Capitol, the moment of and CCTV footage, which has the timestamp on it, at the moment of the confrontation, other video was found showing David Lazarus in the tunnels with members of Congress who were being evacuated.
Oh, so he wasn't even there.
Wow. He wasn't even there. Now, the problem is that wasn't discovered until the 44,000 hours of videotape were released, which included video from the tunnels, which was not part of the original 14,000 hours of videotape that was given to the defense. So we didn't even have that, or I wasn't in the first trial, but the lawyers in the first trial didn't even have the tunnel video at the time of trial. And Steve pieced this together himself afterwards.
Obviously, the government had that video.
Right. He pieced together that, well, what the government will say, as you and I have discussed many times, what the Department of Justice will say is that video was in the possession of the U.S. Capitol Police, an agency of a separate branch of government. So therefore, it was not within the control of the Department of Justice, and as a result, does not fall within the definition of Brady. And that's exactly what they said.
Yeah.
But this all came to light post-trial, and is now obviously an issue being raised on appeal.
Okay.
So Steve reported that. So Steve, we also have information. Steve has inside sources that have told him that it was the chief counsel for the U.S. Capitol Police that insisted, to the extent of having shouting matches with DOJ officials, that Steve Baker be charged.
Had to be charged. So they charged him with,
so they charged
misdemeanors?
Yep, 4 misdemeanors. We made a decision last week. We made an effort to mount a selective prosecution claim, since we could identify 80 other journalists who engaged in the same physical conduct as Steve, going onto the grounds and into the building, covering the events, including one named Luke Mogelson, who wrote a firsthand account of being among the insurrectionists that he sold to the New Yorker magazine 9 days after January 6th.
Right. He's not charged.
No, he was not charged, but his story is in effect a confession to everything that Steve Baker did. The only thing he didn't do was say, I support everything that happened 100%. And so the argument I made, which ultimately was not accepted for reasons I think I explained, is the only distinction that the government can draw between Mr. Baker and these other journalists they didn't charge was Mr. Baker's opinion fell on one side of the political commentary spectrum, and the other journalists either were on the other side or didn't say a thing. Luke Mogelson was very critical of the protesters in his story for New Yorker magazine, and of course his confession published in a national, international magazine doesn't lead him to be charged because he condemned the activity.
Right. So which judge do you have in this case?
We had Judge Cooper.
Okay.
Now I'll say this, it's maybe stepping out of school a little bit, but I suspect, it's just my suspicion, that our motion for selective prosecution it's a very difficult, claim to make, that.
Yeah, so people know it's a very difficult defense to succeed
a very high bar to climb. And when the grounds are political as opposed to racial or something like that, it's even more of a long shot. But I suspect that a factor in the decision making was it was only a misdemeanor case. And I can see a judge saying, look, if you want to take this up with the appellate court on a misdemeanor case, feel free. What are the chances of that really happening? So today, Steve, we had made a decision last week that he was not going to sit through a day and a half of listening to the government, what he called, Steve has
smear something.
Shaming exercise.
Shaming, that's what it was, yeah.
Steve for his political views, and that being the justification. Because what the government does is they use the political expressions as evidence of his intent to interfere with the proceeding. Well, you were a Trump guy, and therefore your real reason for going inside was not journalism. That's just your facade.
Cover story.
Your real reason was, to participate. Well, as the government said many times in writing, as we battled back and forth, Mr. Baker joined the mob. It's all about the mob and who was part of the mob and who was only taking pictures of the mob. And, so dangerous First Amendment ground. And, today it's funny, talking to, 4 different reporters, all have covered many trials. I know them all. And I was looking at them, I'm thinking, do you guys realize that you're now on the wrong side of the political spectrum vis-a-vis the incoming Department of Justice?
Yeah. Right. Is that what they're going to expect?
Now, how comfortable do you four from AP, the Washington Post, Politico, and a local station, how comfortable are you guys right now with what just happened?
Right.
So.
But okay, So he pled
Now,
guilty basically to get it
yeah,
over
yeah,
with.
essentially, I wasn't going to
Yeah.
sit through the shaming process because we're quite confident that President-elect Trump is going to follow through with the campaign promises he made, and given the nature of the offenses, Steve's case, and even this, you'll find this, interesting. So we get through the plea process, and the judge sets the sentencing for March 6th. Now, that's generally
Okay.
the end, right? That's usually the last thing that happens. And it's like, we'll do a PSR, I'll be prepared, and I'll see everybody back here on March 6th for sentencing. Judge Cooper says, well, acknowledging the fact that we likely will never see each other again, Mr. Baker, a few comments I want to make. Yeah, and then he went on for
Oh.
10 minutes to basically chastise Steve for his conduct and his commentary, and defending
Oh,
the integrity of the Department of Justice and the courts in the way they managed the January 6th prosecutions.
that is totally inappropriate.
But,
Totally
but
inappropriate.
it was going to be his only chance.
Yeah, right. It's his only chance to scold from the bench, which is mostly what judges do during sentencings. Uh, so, yeah, okay, that's charming.
So yeah, it was an
Well,
interesting morning.
yeah. Well, congrats in a way, right? It's a good resolution for that client in the sense of because you know what your legal options are and what you've got the possibility of the soon to be president's, prerogative to pardon.
Well,
So,
there
what?
was a little bit of an interesting twist on the circumstances of the process by which the plea was taken that I'll explain. Just give me a couple minutes. So I write a fact. So because he's going to plead guilty to all 4 counts, we don't have an agreement with the government. We're not locked into the government's statement of facts. Usually when you have a plea agreement, you're obligated to all the terms of the agreement that you agree to, and one of the ways the agreement comes about is the government writes the facts, and you're stuck
Right.
with it. It's take it or leave it. Do you like these facts, or you accept these facts, or you reject them? If you reject them, we don't have a deal. We'll go to trial.
Please
Right.
off. Right.
So they have you over a barrel. You have to take what they write. But when you're going to plead guilty to all the counts, you don't have an agreement with the government. You're just saying, I'm pleading guilty to everything I'm charged with. And then
Right.
we write the facts. Well, I was trying to figure out, how do I want to say what we're willing to say without treading into waters that we don't want to go into because we don't want to acknowledge or admit. And it occurred to me, if I use the TikTok, meaning just his sequence of events along the way, which he had recorded. So it's like there's not any dispute over what he did or where he went or even his commentary at various points in time. It's
Right.
all recorded. I said,
Right.
if I use the TikTok taken directly from the criminal complaint affidavit signed under oath by the FBI agent, who is going to be able to contest what I use?
Right. What are they going to say about that? That's not what happened?
Exactly. So I did. So I went through, I
Ah,
clipped word for word. I had deleted certain parts I didn't want to use. I put in ellipses, but I quoted directly out of the complaint affidavit. But I left out the
okay.
editorializing.
Yeah.
And what I did not say in there was that at the time he entered the building, he did so with the purpose of impeding Congress. Okay.
Right.
So we get to the hearing, and this obviously is troubling the court, and it deals with 2 counts where an intent to do something inside beyond journalism is an element of the
Mm.
offense, and I didn't write that in there. And the judge, after he goes through it with Baker, he turns to the prosecutor and he says, "Mr. So-and-so, are you satisfied with this factual basis?" And they start to have some issues about it doesn't go far enough. It's specific intent crime. He needs to admit that's what he intended to go in, and so Cooper. I mean, we all know the minefield we're walking in. Are we going to blow up this plea because we are not willing to concede certain issues in the form of an affirmative factual statement? And there's exasperation is building. I have to have a couple of conversations with my client where we discuss, sort of how we maneuver through here without him having to say what he
Yeah.
doesn't want to say, which would undermine his
Right.
representation that I was there committing journalism. And I finally just said, I heard Mr. So and so, I don't want to use too many names. I heard Mr. So and so mention to the court at the outset that, based on that intent is often inferred from conduct. And I said, we
Right.
are not denying the
We're not going to
conduct,
fight you.
and we're
Good.
not offering an
Right.
alternative scenario of intent. And the government has put other evidence before. In fact, he asked the government if they had evidence that they, or what other evidence they would offer. So we're not being
Right.
asked to concede that evidence. We're just asking what other evidence they would offer. They went through his commentary, and so I finally, I didn't have to pull out the big gun, which is what I have used a few times, which is a change of plea is not a confession, not the same thing.
Right. Right. Right.
You don't,
Exactly. It's a legal
right?
device. That's
And
it.
and I didn't have to go that far, but I basically made that point is that the court is aware of the other evidence. The court's only decision it needs to make whether there are sufficient facts to support the plea. Doesn't have to
Right.
draw express concessions out from the defendant that he doesn't want to make. He's choosing not to contest what he did. And if you want to infer his intent like a jury would be told it could do, that's up to you. And at that
Right.
point, you know, it was like, it's 4 misdemeanors. Can we just get this over
All right. So
with?
can we just move on? Right.
And so once we sort of got past that hurdle, and it's 4 misdemeanors where we're likely never to see a sentencing hearing.
Right. So what
Yeah.
are we
So
doing
what?
here,
So
Jake?
it's like just we teed it up and said take it or don't take it, but this is all we're doing. And at the end of the day, it was enough.
Right. But he wanted to bark at the
Right.
client still. Yeah. So, okay. All right. Well, congrats. And hopefully that case takes a turn even for the better for the client once the former soon to be again president takes office. Okay. So, what we're going to talk about now is let's switch over to Meadows. King, you want to take the lead on this and remind people where we were with it?
Yeah, Meadows uh, appeal to the 11th Circuit uh, raised two issues. He he argued that the 11th Circuit inappropriately or improperly construed the law to apply only to current uh, employees of the federal government. If you were a former employee like he was, you had no right to remove the case, even though you had a slam dunk federal defense to the case. That's what it would. For 100 years, former federal employees have been removing cases to federal court under this law. But here, for the first time, the court in Atlanta, and then the appellate court. Uh, the trial court didn't even rule this way. The appellate court held, reading the law, literally it says employees. It doesn't say current employees and former employees. So they limited
Right.
its scope only to current employees. He tried to take that issue and the issue of whether um, he was on the merits of the case, whether the law applied to him or whether the appellate court uh, wrongly required there to be a causal relationship between the the conduct, his conduct, and the federal defense he was raising. Uh, that he argued that used to be the law, but Congress amended the statute in the past 8 or 10 years, and it's no longer the law. It's a much looser uh, relationship test, not a causal relationship. His defense didn't have to actually cause uh, the conduct that led him to be charged. Anyway,
All right.
that
So
I
this is
garbled
great.
that.
sounds very
I garbled
convoluted.
that,
So
but
yeah, let's see if we can simplify.
he's got two grounds he he brought to the Supreme Court, and they turned him down.
They turned him down. Okay. So to shorten that, so maybe help people understand a little cleaner, the state of Georgia charged Meadows and Clark and others. And the federal officials, who were no longer federal officials because of the turnover of the administration from Trump to Biden, said, you can't try us in state court because we're federal officers. We have a right to go to federal court instead. Okay, and there's a federal statute that allows for that. It's called removal. And that statute applies to both civil and criminal cases. And the trial court in Georgia said, no, you guys, Meadows specifically, we're talking about tonight, cannot move the case from state to federal court because I don't think that what you did is enough, federal enough, basically, to where you should have this removal protection. You have to stay in state court. Meadows appealed that to the 11th Circuit. The 11th Circuit took the case. They have to. They don't have the same situation as the Supremes where they can pick and choose their cases. They have to take appeals. So Meadows appealed that ruling. And he appealed on the grounds that the trial judge just got it wrong, that he wasn't acting within the scope of his federal employment, or that there wasn't enough linkage between his federal job and what the charges were. The 11th Circuit, though, injected a new issue into the case, which is, does the statute even apply to former federal officers? And they had another case where they were analyzing another statute where they dealt with this issue, and there was a difference in the language. And so they said, we decided this other case that has this difference in the language, and we think the same thing might apply to this statute. What do you guys think about that? So then both sides briefed that in the Court of Appeals. Court of Appeals denied Meadows's appeal on two grounds. One is this statute does not apply to former federal officials. I'll explain that in a second. And also, yeah, we think the trial judge got it right that what Meadows was doing isn't sufficiently connected as part of his federal job with what the charges are. Now, the second part of their opinion reads like TDS gone crazy to arrive at this miraculous, in my opinion, conclusion that what Meadows was doing somehow wasn't the work of a federal officer, and that that's not what he was charged for doing. They're just bananas, bonkers, out of their minds concluding that. Okay, but the real issue then has become, okay, but what about the statutory language? Does it apply to former federal officials or not? It clearly does for civil cases. The language specifically says that it does. It says if the person is an officer or was at the time that the action accrued. So, whatever the thing was that they did that's getting them sued, when that thing happened, were they a federal official? On the criminal part of the section, it does not have that extra language that says that you either are a federal official or were at the time of whatever the conduct was that caused the offense. And so, or that is the basis of the offense that the person's charged with. And so the 11th Circuit said because the criminal section doesn't have that language, that means it doesn't apply to former federal officials, it only applies to current federal officials. Okay. And pretty much, as King was saying, pretty much the other circuits had allowed officials to use this statute. The 11th Circuit's opinion goes through those cases. They kind of say, well, these weren't really cases that matter or make a difference for one reason or another. They don't agree that sort of like it's always been applied that way to criminal cases. It occurs to me that pretty much the history has not been that people who were federal officials have been indicted in the state courts after leaving office. And so there aren't that many cases to look at to begin with. But the ones that there are kind of tend toward, yes, you're allowed to do it. I think the circuit's not being quite fair about that either. But they did have something to say and do have a lot to say about the language in the statute. It's extremely unfortunate from the point of view of sort of drafting legislation that the two sections don't read the same. Now, they were not enacted by the Congress at the same time. There's, I think, 60 years difference between the two statutes. These statutes are pretty old. And they were combined into the same, next to one another in the statute books in the 40s, but the statutes themselves are even older than that. They were passed long, 3 decades apart, 6 decades apart from one another. So the circuit, looking at that language, said that it seems pretty clear, just reading the text, that one applies to former officials and one does not. So we wondered, once that issue got injected into the case, this was Meadows's case was decided by the circuit in, I think, November or December last year. So we're coming up on a year ago. We wondered if the Supremes would be interested in sorting that issue out or not. Because, you got a bunch of textualists and originalists on the bench right now. And what are they going to make of this argument about, well, the language literally doesn't say it includes former officials? It sort of doesn't make any sense that it doesn't, but that doesn't change the words on the page. And then when you compare it to the civil section, which is right next to it, that does have that language, it's problematic. So, Meadows, we always thought, had a good argument that he should have been able to remove his case. And as we've said many times, we all think that Jeff Clark has an even better argument that his case should be removed. The circuit, King, what's the date? Do you remember? The circuit just decided Jeff's case, right? So
Yeah,
he can still file for cert if he wants to as well.
yeah,
King, go
they
ahead.
they decided Jeff's case denied his appeal on the same grounds as Meadows. Uh, I don't know. I don't have the date, but it's in the last 2-3 weeks, I think.
Right, it's relatively recent. So he can still seek this, but this obviously the Supremes turned down Mark Meadows' case today. Now they don't say why. They considered the case. It was fully briefed. We talked about this a couple of spaces ago. It was fully briefed, I think the week before last. They took it up in their conference on Friday, and obviously they decided they weren't interested. They issued their list of orders of cases that they're taking action on. They do that usually on the Mondays after the Friday conferences, but yesterday was a holiday, so they issued that order list today. And it just reads like a list, case numbers, names, under the heading of cert denied, right? So there's no commentary. It doesn't say how the justices voted. One thing you can say is that it takes 4 justices to say they want to hear the case. It takes 5 to win the case, but only 4 for them to agree that it's a case that should be heard. So no more than 3 of them could have been interested based on this order that they put out today denying it. But I wonder, this is what I wanted, in addition to informing people about what happened, I wondered what the two of you thought about, do we think that that textual argument made that case unattractive then for the conservative justices? Um, and if that's the case, then we should probably discuss whether or not the Congress should amend that statute to make it clear that it does apply to former officials, because we're in this brave new world now where we indict former presidents and other former government officials. And going even farther, if the Congress were to amend the removal statute to permit former officers, do we think legally that would apply to both Meadows' case and Jeff Clark's case? So I throw that open. King, you go ahead.
I think I, looking at their denial of cert and considering the conservative minds on the court that are in control, I think you nailed it. I think they did not want to jump into this case and use historical. This is the way we always did it, but nobody ever looked at the words of the statute. They didn't want to get into that in this particular case because there's another issue that sometimes drives appellate decisions, which is they don't, as a matter of rule, don't go out of their way to expand court jurisdiction when there's not a clear statutory basis for it. They they they'd rather take fewer cases than more. And so here you have a statute that the lower court read and construed as limiting jurisdiction, that is removal jurisdiction, to only current officers. That's consistent with the grammar and the words of the statute. And so to take the case, they would have to go out of their way to come up with some rationale as to why that language didn't mean and wasn't limited to its words, what the words actually said. That's
Let me ask you this, because I think we alluded to this before, if not outright said it. If you didn't have the parallel civil section that has the specific language in it that clearly does include former officers, if you didn't have that to compare to, I think there's a good argument that the words on the page do include former officials because it kind of doesn't make sense that they aren't included. You follow what I'm saying?
yes, and that's the anomaly here. Those two
Right.
s- sections, one civil, which spells it out, and the other criminal, that is more, it's broader in one sense, but if you look at the words of the statute, it's more narrow than the civil. Those came into the law books decades apart from one another. They're
Right.
not, they were not passed at the same time. Congress,
They were not passed by the same Congress at all. So, yeah.
so it's unfortunate because normally when courts construe a law passed by Congress, they take the law passed by a single session of Congress and kind of read the various sections and subparts of that law so that it makes sense and it's logically consistent within that law. Here you've got two laws passed many, many years apart, and they're treating it as if that is, the 11th Circuit treated it as if they were passed by a single Congress at a single time. So you have to construe those two sections differently. Uh,
Coherently
right.
together, right. Yeah, you could, if you were only dealing with the criminal section, you, I think, could make a very persuasive argument that the federal officials include former officials because the point is you had to be a federal official at the time of the conduct that gives rise to the charge. So that's the way I think you would read that language, even if it wasn't specifically in the statute. And one way of looking at it would be to say, even though that language specifically is over on the civil side, it still means the same thing. But the fact that it's in one and not the other gives rise to this argument, which the 11th Circuit accepted, that the fact that it's in one and not the other means it doesn't apply in the criminal. That's not the only way to look at it, but we said at the time when they came up with this, okay, there's an argument here. You can see why they came out the way that they did. Um, and with the conservatives being textualists and so forth, you maybe they just didn't want to be put in the position of saying this statute doesn't mean what it literally says, and the liberals saying, "Aren't you guys the ones that are always saying statutes mean what they say?" um, well, before we move to whether the Congress should amend that and what happens if they were to do so, do you guys think the election played any role in them taking a pass?
I have to think it would, or it did, because that was the message of the the 11th Circuit, actually. They said this, yeah, we understand we're construing this differently than what everybody thought it meant, but it's up to Congress to make it clear. And after the election, now they have a chance.
Right. So, there's less chance probably that Meadows and Clark will get gored with this section with the president returning to office. Ship, are you with us on this? Why reasoning of why the court probably declined to take the cert?
Yeah, I mean, obviously, we're early in the term. They're only going to take 75 or 80 cases at the end of the day. They're going to turn down thousands and thousands of cases. And I think leaving this case, first of all, I think there's probably a working presumption that the case never goes forward to trial in a Georgia courtroom, regardless. And
Instead for other
and as
reasons.
long as it remains as is, there will be an urgency attached for Congress to fix this statute.
Right. This is what I think too, that the conservatives are trying to say we're not going to fix this because the Congress has a drafting issue here. They really should fix it. So
And then
let's
it's and then it's clear, and there's no confusion.
right, and then it's clear on both sides, and everybody knows what the rules are.
And
Right.
these issues that have had to be litigated through the 11th Circuit would all be resolved if Congress would speak more clearly about what it wants to do in this factual scenario.
Right, and make sure we all actually do understand this. Okay, so I think that the Congress should amend this. I mean, regardless of which side of Meadows and Clark's case you're on, or which side of the January 6th you're on, or any of that, these statutes need to be clear and they need to make sense read together. And we're either trying to, as a policy matter, allow former government officials to defend themselves in federal court versus state, or we aren't. So which
Hey,
is it?
let me. I presume you see. I don't know if you do or not, so I'm just going to say it. Jeff Clark is here. I
Yeah, I
don't know
sent
that
him a
I don't know
message.
that Jeff
No, I
will.
sent him a message
He may not
asking
want
if
to
he wanted
comment.
to.
Um,
Right, exactly. So we're going to leave him alone until he says he wants to talk, because we don't want to put him, Jeff. We don't want to put you on the spot. If you want to talk, then you can respond to my DM, and please do. Don't be shy. Um, so I am going to advocate that the Congress needs to amend this. They need to straighten it out. Don't you guys think so?
Absolutely. I
yeah,
think.
yeah, and there's a variety of vehicles they could do it through, but I think in some ways Congress needs to develop a more consistent habit of fixing small things with small fixes.
Right, exactly.
For example, Rule 48. Like, how about
Yes, Rule 48 needs a lot of
if
work.
you clear up what leave of court means?
Yes, why don't you just take that out since it's
Yeah,
unconstitutional
they
anyway?
can have
Yeah,
lots of little fixes, and it doesn't have to be bound up in complicated legislation as some little writer somewhere. Just
yeah,
somebody write a fix, send it through a committee, get it onto the
right.
floor, vote on the damn thing, send it over to the Senate, and have the president sign it. Since
And there's actually lots and lots and lots of these, and I've been keeping a running list, and I think I'm going to publish something about it. What these are what I call my a priorisms. There's lots and lots of things like this. Like everyone was all bent out of shape when the feds are arresting people instead of doing summonses. Well, the Congress is in control of that. The Congress is also in control of how early in the morning government agents can storm up to your house, to execute those warrants. They need somebody. I think you're right, Chip. They need somebody to just point out to them, look, here's all the things that are messed up, and it doesn't take that much work to fix them. So I'm going to be doing that, I think. But let's turn to the question of, let's say the Congress does amend the statute while this case is pending, and let's pretend for a moment that it's actually going to go forward, because I agree with you. If Fannie Willis gets disqualified, if there's other problems that are being already taken up by these guys who have very capable lawyers taking these other issues up in the Georgia courts, that case may never ever go to trial. So, okay, but setting that aside for the moment, let's say the Congress amends this statute to make it clear that former federal officials are covered while the case is pending. I know people are going to ask, well, will that help Meadows? Will that help Jeff Clark? So let's talk a little bit about this. Steve and I were debating this and researching it a bit today. It looks like retroactivity in a way. Steve is convinced that it is retroactivity, and that they would benefit from a change if the Congress was clear enough about it. So, King, you want to weigh in on this question?
And, well, first, when would the Congress amend? If we're talking about 2 years from now,
Wow. Yeah,
uh,
right. No, I was thinking either during the lame duck or, next spring, let's
let's say
say.
in spring. Let's
Yeah.
assume it happens in the spring. Uh,
I mean, we have control of course, we don't have control of the Senate at the moment. So let's say in the spring when we have control of both houses. And by we, I mean right of center.
uh, yes, Congress can write the new law to expressly make it applicable to pending cases. Uh, they would have to do it in a way that would permit I guess, a second removal by Meadows. They may be able to do it before Jeff Clark's cert petition is decided by the Supreme Court. Um, he was not in the Meadows case. That so he still has his own right independently to apply for cert, and assuming he does, uh, it's possible that the Congress could act in advance of the court considering his petition for certiorari. Uh, as to Meadows, they would have to write their law to permit him to somehow revisit his the remand. What happens is when you remove the case to federal court, your case gets filed in federal court. You're asking the court to take the whole case into federal court, and you try it there. When you're denied that effort, the federal court uh, enters an order called a remand order, sending the case back to the state court. Uh, so in Meadows' case, his his case by by way of denial of certiorari, his case will be remanded back to uh, state court. And to get it out of state court again, he's going to have to file a second removal. So the law
Right.
will,
And the statute already allows for that. But you need leave of court.
you need leave of court. And
Yeah.
to be safe, Congress would have to put something in the new law to permit that to happen.
I think to be safe, that's right. So I want people to understand. In general, if the Congress passes a new law and it applies retroactively in the sense of it applies to things that have already happened, the law disfavors that. And in fact, in criminal cases, there's even stronger prohibitions. So I'm sure most people know, in general, the idea of ex post facto. This means you can't be punished, you can't be fined, you can't be incarcerated, you can't even be found guilty of laws that didn't exist at the time that you did the conduct. Okay, and there's various permutations of that, but that's the general idea. But the same rule sort of applies in a less strong way, it's certainly not constitutional, on the civil side, where the courts say retroactivity is disfavored because we don't want people to be even civilly held responsible for things that weren't against the law at the time. But there are still lots of statutes that the Congress writes that apply retrospectively, backward looking, because cases are pending at the time that the Congress is writing legislation. I mean, this is just an ongoing, time keeps moving forward. So, although that's disfavored, it isn't unlawful or even unconstitutional for the Congress to write a statute that applies retroactively and changes things going back. What I find interesting is this question of okay, but for cases that are still pending, are you even really doing retroactivity? So let's say Meadows decides to plead guilty. He probably won't, and I probably wouldn't advise him to, but let's say he decided to, right? He pled guilty, he got his sentence from that judge down in Georgia, and then the Congress amends the statute. But his case is done and final and over, and they amend the statute to allow removal for former officers. That would really be retroactive if at that point he's trying to take advantage of that statute. But that feels to me different from a situation where the case is still pending, but the Congress is changing the law. So, like the law is morphing while you're in the process of your case. So, I wonder if it actually is retroactivity. Um, but maybe it's like retroactivity light. When you're changing the statute. So, but King, I think you're right that the clearest thing would be for Congress to say that the changes would apply to any case that was still ongoing, that wasn't final yet. Ship, you want to weigh in on that?
Yeah, I think after you've pled, Congress changing the law isn't a declaration that the law was inappropriately applied. It's just going forward, changing the law. If your case is still pending, you can take advantage of the change in the statute. I guess what somebody in Meadows' position would be if they had pled guilty would be seek to undo the plea. If you can get it
Right.
undone, then you take advantage of the statute and move your case to federal court.
And there are a couple of pleas in that case, right? So, didn't Jen Ellis, Sidney Powell, a couple other people that pled in that case? Now
Sidney
they,
Powell plead in that case?
yeah, she did. Although she didn't have the argument that she was a federal officer at the
Oh, that
time. But
okay.
Jen Ellis, was she?
And the other interesting thing, though, and this is complicated by the president-elect being a defendant, is if
Mm,
one defendant is eligible to have their case removed, does the entire case get removed?
yeah, that's what the case law says. The answer to that is yes.
So everybody
So,
benefits.
right,
Okay,
exactly.
now you have the president-elect can't be part of the case. Well,
Right.
um,
Right. Yeah.
although that's a DOJ policy, not a Fulton County DA policy.
Right. And I want to talk about that when we get to New York also. So put a pin in that for a second. But okay, so it sounds like we're agreed that the Supreme's probably dodged this because there's this language issue that it would be better for the Congress to address rather than them. The Congress probably should do that, and they can probably do it in a way, expressly or impliedly, that gives relief to these defendants in this Georgia case. So, you know, to me, that's just pretty clear. That's what they should do. I think it's absurd that former federal officials who've been indicted, where for clearly for things that they did that were part of their official duties, and in Jeff Clark's case, where the Supreme Court of the land, no less, has said that what he was doing, we're talking about what he was charged with, that those actions are immune from prosecution in the first place. So, how in the world we arrive at the conclusion that he can't say, I need a federal judge to hear that rather than a state court judge, just boggles my mind. But the language is what it is. Ship, what were you going to say?
Not me.
Oh, well, you unmuted yourself. But it's like this is a situation where it's like poor drafting, right? But the problem is you can't, and certainly as conservatives don't think that judges can rewrite the statute to say what the Congress meant as opposed to what the words on the page say. So I really think that's why they turned down the cert today. But hopefully there is a successful resolution for those guys and for President Trump in the offing on that case. Shall we turn to the New York case?
Been waiting, yes, with bated breath.
Okay. Are you going to tell us what happened in that case today? And if you are, can we do it in a non-ramble?
I apologize for that first ramble because I had dozed off,
Oh my
and I
goodness,
woke
King.
up just when you called on me.
Oh no. So you weren't fully
I was
engaged. Your
yes.
brain wasn't.
This one I'm ready
That's
for.
okay. I put you on the spot,
You
so
didn't.
that's my
Well, no,
fault.
no, that happened. It brought to mind all those years in college and law school where you tend to do that. and get called on by the professor. Um,
Right. And you're like, wait, what class am I in?
that's it. So, uh, pending before Judge Merchant in the New York criminal case against Trump was first, and the judge had announced in his schedule that on the 11th, which was yesterday, he would decide the defendant's motion to dismiss the case on the grounds of immunity in light of the Supreme Court's immunity decision. In
Which was peculiar because he said he would decide something on the 11th of November, which is a holiday. So I guess he failed to notice that that was Veterans Day. It's always been Veterans Day, hasn't it? Although it used to be Armistice Day. But I'm saying that that's been a
yeah,
federal holiday and state holiday for since the end of the First World War. But
yeah,
okay,
but he didn't set it for hearing, so he left himself some room. I guess he could have written it,
he could have been working
been
on the
working on
holiday,
it,
right?
and he could have filed his decision or opinion early. But that's when he said he would decide that
Right.
motion.
But he
But
didn't.
he didn't. The next thing on the calendar before today was sentencing, scheduled for next week. And but today, uh, actually starting last week, he he got some correspondence from both sides, both the prosecution and the defendant, uh, advising the judge that look, uh, Mr. Trump had.
Meanwhile,
Yeah. You may have read, Judge, that in the paper that Mr. Trump won the election. He's now president elect. Um, he will be president, presumably on when he's sworn in on January 20. But in the meantime, he is in the transition process,
he's a little
and
busy.
there's a federal statute about that sets out procedures whereby the president-elect and his uh, prospective administration go through a transition process whereby they get geared up to take over the country on
Take over the
the
government, not the country, but
well, you're quibbling, but and that takes a lot of time, and you don't want to be you don't want to have your man kind of worried he's going to be sent off to Rikers Island in the middle of it, because if he is sent off to Rikers Island during that transition period, and especially after he's sworn in as president, you have a federalism issue. Which
yeah.
which which law trumps? The federal law that says he's transitioning to be the president, and then on January 20th, he is sworn in to be the president in charge of the executive branch of our federal government. Does that law is that law superior to a state law that says he's guilty of a felony and he's got to go serve a month at Rikers Island? The answer is obvious. The federal law wins, and no state can put the president behind bars and prevent him from undertaking the duties of his federal office.
So let me jump in and interject some facts here. So the procedure, I mean. So the Trump lawyers had already filed this motion to dismiss on the grounds of immunity because Alvin Bragg's office used information that the Trump lawyers are saying is immune. I agree with them. We talked about this before. They used a number of things that they just should not have put into the case. And Judge Marchand made this problem for himself by refusing to keep it out, saying he was going to rule on it on a case by case basis instead of ruling on it pre-trial. I mean, he's created the problem where he now has a jury verdict that's tainted by this immune evidence. Okay, so the defense lawyers had asked for the case to be dismissed on that basis. That's what he said he was going to rule on by yesterday. And then Friday, the Trump lawyers said, oh, and by the way, you should also dismiss on the basis that King's just laid out for us. So they must have also communicated with Chambers over the weekend or yesterday on the holiday, because the prosecutors now they would like time to respond to this argument about that because Trump has been elected president, the case should just be dismissed because we can't be proceeding on a criminal case given his status. So the request to punt the case actually came from the government, and Judge Marchand today agreed that he would set off any rulings or whatever it is he's going to decide on until a week from today. Now,
In,
my question, go
yeah,
ahead.
in the government's request, which was agreed to by the Trump
Yeah.
defense team, uh, was exactly the same thing that Jack Smith did.
Yeah, that we talked about the other night. The language is very similar, isn't it? They want time to consider
Yeah,
this unprecedented
we
development.
need to scratch our heads a little bit and ponder where do we go from here.
I mean, even writing those maybe should give you a clue, right? You've just written in your pleading that you're going to file with the court, that you have to think about what you're going to do about your case, your criminal case, because the defendant that you're prosecuting has just been elected president of the United States. Maybe that should be a clue to you that you shouldn't have brought this case in the first place, or that you definitely shouldn't be pursuing it at this point. But somehow they can't comprehend this. So,
Well,
yes,
and it's driven by the basic fact that there is no way that a court legally could one punish through probation with terms with or with jail time. Uh, there's no way, or even require the president elect to sit in court for.
I'm not sure about that, but I want to debate that issue because I've been wondering, okay, what are Marchand's choices here? But the choice that he chose was, I'm not going to decide this today. I'm going to give the government time to brief this other ridiculous, dimension, and we'll decide next week what we're doing, which is defeating the purpose of Trump's lawyers' motion, which is that, our guy's pretty busy preparing to be president of the United States at the moment, Judge. So this case needs to be over with. But okay, I guess they figure it's early in the transition and one more week's not going to matter. But okay, so, but also, if Marchand has already decided to dismiss the case, dismiss at least the jury's verdict because of this tainted evidence, why didn't he just announce that? He could still entertain the other motion.
That's the easiest way out for him. If he wants to get rid of this case cleanly and for good, he can he could rule as Trump and his lawyers have asked him to do, which is, Judge, the jury heard evidence of conduct that the Supreme Court has held was presumptively immune from criminal prosecution. And not only that, you cannot use that as evidence in a criminal trial against the former president. So that happened. There's no dispute that some of the presumptively immune conduct of Trump when he was president was presented to the jury
Right, both through testimony and
and
documents.
and,
So,
and argued by the DA uh,
right,
at,
in
in
closing,
closing
yeah.
that it's proof of his guilt.
Right. So I agree with you. It would have been an easy way for Marchand to get rid of the case, quote unquote. Literally, all it would do would be get rid of the verdict, and then he could dismiss the indictment as being tainted, also, I suppose, and then tell Alvin Bragg's office, you guys figure out whether you think you can re indict this defendant or not. But let's play the game being more charitable to Judge Marchand. Maybe because he did do the right thing by saying, I'm not going to decide any of this nonsense before the election because I'm not going to interfere with the election. Okay, good. We gave him credit for that. He deserved it. Other judges in these cases didn't go that way, right? But this judge did. Maybe what he would like to do is have it in his hand to control and not just vacate it all out, zero it all out, and then put the ball back in Alvin Bragg's court with the understanding that Bragg's going to spend however long he wants trying to decide if he can re-indict Trump or not.
I think he's kind of lost at sea right now. He's waiting on Alvin Bragg to tell him what to do.
Could be, but he could have. You see what I'm saying? He could have said, I'm getting rid of this conviction today, and you guys can go back and figure out whether you think you can re-indict him. But meanwhile, this case is off my docket. Thank you and
Well,
goodbye. That would
an astute judge wanting to get rid of this case would have done that. Why he didn't?
Yeah, but what I'm saying is, if by not doing that, he's not just leaving it ambiguous and up for Bragg's office, right? If he grants the Trump motion to dismiss the case because the president just can't be hailed into criminal court, that's more final, right?
Exactly. Yes.
Yeah. So maybe he wants to do that and he's going to give Alvin a week to come up with whatever his arguments are, and then he's going to do that. I mean, it's going to be fascinating to see. But let me ask you guys this. People have asked us, we have been clear that, the federal policy on not indicting or prosecuting a sitting president applies to the Department of Justice. It's guidance from the Office of Legal Counsel to the DOJ that it's binding on them. No court has ever said that that's what the law is or what the Constitution requires. But obviously, DOJ is the one that's in charge of indicting people. And so if they say they can't do it, then it can't be done. But I'm toying in my mind with the idea of why, if that's the law, because it flows from the constitutional separation of powers principle that the courts can't sit in judgment of a sitting president in that way. Why wouldn't that necessarily also apply to the states via the supremacy clause?
I think it has to. You To me, it's a black and white issue. You and open and shut. You cannot have 50 states uh, using their state laws to tie up the federal government.
Right, because the theory of OLC's memo is that it's an interference of the executive branch by the judicial. So this would extend the argument to be it's an interference of the federal executive by the state executives, and under principles of federalism and the supremacy clause, you can't have that either. Sort of akin to the Colorado decision that the Supreme's just made about how the states don't get to enforce the insurrection clause of the 14th Amendment.
What about Clinton v. Jones?
Steve says, what about Clinton v. Jones? What do you guys think of that?
It's Clinton v. Jones was not a criminal case.
Right, it was a
Where
civil lawsuit.
it
Yep.
was a civil case only, and it did not require Clinton to. I mean, he was not required to be in court, present before a jury, and be subject to criminal penalties. Uh, I thought everybody at the time believed that a criminal prosecution would have to wait until after he left office.
Right.
Yeah.
But so for people who don't know, Clinton v. Jones, the Supreme Court case, they said that the sitting president could be pursued in the civil courts. Now, I will say, I thought that was wrong, right? Now, I thought Bill Clinton was a dog and he should have resigned. And I thought if he'd had any honor, that's what he would have done. But of course, he doesn't have any honor, so he didn't. But the question of whether the president could be pursued in civil litigation, I thought was insane. And interestingly, Justice Kavanaugh apparently has repented that view as well, right? So he was involved in the Star stuff, but as a justice, he's made comments in at least one case saying, we probably got that wrong.
For for,
He,
for people not as old as me, uh, the Jones in that case was Paula Jones, who
not Tom Jones,
yeah
the
yeah
singer.
yeah the Paula Jones was one of the women that came out of the woodwork accusing Bill Clinton before he became president of
Right, he was credibly accused, as
he
the
was
left likes to
accused of
say. Yes.
I think uh, one of Clinton's campaign people when he was first ran for president famously called them bimbo eruptions from dating back from when he was governor of Arkansas. He apparently had
Right.
quite a reputation with the ladies, and some of them, particularly Paula Jones, accused him of um, improper conduct and filed civil suits against him while he was president.
Well, he was governor.
I mean, the suit was brought
Oh, okay, yeah. The action was
while
Right.
he
brought
The
was
after he
conduct
had
president.
was the
become elected,
conduct for
right?
her was while he
But
was
the
governor.
conduct
Mhm.
happened before he became president.
Yeah, and I think
Right.
that was part of as I recall, I haven't looked at the opinion in a long time, but the two key factors there was he was only being asked to submit to a limited amount of discovery, including a deposition, and that it was for conduct predating his time as president.
Right.
The the the
Okay.
the limited burden
Right.
on his function as president, I thought was one of the key parts of the
Right, that's what
opinion.
they said,
Eh,
but that's not like reality, right? I mean, if you've got even Justice Kavanaugh saying, that's kind of a naive way of looking at the office of the president, right? To say, oh, well, this won't burden you too much. Well, what if this deposition happens to be on the same day where you're having to make a
Yeah.
decision whether you're going to off Soleimani or not, right?
But contrast that with a criminal case where you have to appear in court. A jury's
Oh, you have to sit there through the whole
sit there
trial, whether
through
you
the
want
whole
to or not.
trial
Yeah,
could last for months.
right.
And
No, I'm not saying it's not more burdensome. It obviously is. I'm just saying I thought it would the whole idea that we're not interfering too much with the office of the president. I thought that was insane then, and I think it's insane now.
and then here you have the prospect of uh, criminal penalty, which would include things like prison time, um, probation with conditions, you know, wearing ankle bracelets, home confinement, things like that.
Right.
Uh,
Well, let's get down to the nitty gritty of what Marchand's sentencing is likely to look like. I've said all along, I think he's going to give the president probation. That's going to be the end of it. What he could do instead, and maybe if you were Trump's lawyers, you'd say, Judge, give him time served. Right? He was fingerprinted and photographed, detained for that purpose. And most states that constitutes that you were detained for one day. Marchand could give him one day to serve and be done with it. Now, he would still be legally entitled to pursue his appeals through the New York courts of appeals and get that conviction overturned. But that would be, I guess, more at his election, right? That would still arguably take away some of, his attention while he's president. But as a practical matter, then you wouldn't have these problems of Rikers Island or reporting to a probation officer and all of this nonsense.
what that means is that uh, the menu of options the judge might have in sentencing is very very limited. But it's you can look throughout the law books and you won't find any any definition of how what those limits are.
Right. So even if he gave him 30 days to serve, 30 days probation, let's say, although probably was going to give him more than that, maybe 6 months of probation, you know,
I,
then you run back into the problem of you're doing that to the president-elect. That's nuts.
yeah, well, I don't think you can do it. I mean, I think it is substantively barred by the supremacy clause. That is a state judicial officer imposing the authority of the state over
Right.
the executive of the federal government.
Which can't be done.
Right.
Right. Cannot
I
be
don't
done.
care how de
Except,
minimis it
right.
is, how minor it is. The action itself is barred by the supremacy clause.
Okay, but and I'm just playing devil's advocate for some of these positions. But the question is, we've all said that let's say Joe Biden shoots Jill over the weekend, okay, and he gets arrested for murder by the Metropolitan Police Department. Are we really going to say that the president can't be prosecuted by the states for, let's say it was something that there was no federal jurisdiction for something that clearly is criminal conduct, like murder, right? We're not going to agree with that. There's no supremacy clause exception to the
Pose that
murder.
again.
Okay, so Joe and Jill go out for dinner, so they're not on federal property. You know, they go to dinner in DuPont Circle Saturday night, and he shoots her and murders her. Right? Or at the beach in Delaware. It doesn't matter. So there's no connection to any federal jurisdiction. If he murders his wife, he's going to get prosecuted for that, right?
Well, I think only after he leaves office are impeached.
I think you have to relieve him from office first. Then he can be prosecuted. While he's president, I agree with Ship. Supremacy clause says uh,
The states can't touch him at all
states
for
can't
any
touch
crime.
him, the feds can't touch it, except for impeachment.
Yeah, he is an institution of government. Beyond being a mortal man, he's an institution of government, and you can't take that piece off the chessboard because you're the state of Delaware and you're not happy with what he did on a beach.
So this is really just a question of timing, right? Because that presumably, if he did that, if a president murdered his wife, regardless of where it is, then the levers of the law would start to roll into action, and he'd be removed from office or removed by his cabinet or whatever, right? And then you go down the road of achieving accountability. Okay, but what's interesting is that because they're just floating through the conceptual ideas. No one, as far as I can see, other than the three of us, are suggesting, because the implication of this is that the New York and the Georgia cases have to simply go poof, disappear, cannot be pursued from this point forward, no matter what, based on the supremacy clause. Is that where we are?
I think so, but I think it's a circumstance where whatever statute of limitations might apply is suspended because I think that the legal the legal position would be he is unavailable for state court purposes. And so
Right, he's legally unavailable.
so they could
Okay.
stay the proceedings against him pending his availability. Hey, did I just introduce a developing fact? I'm sure most people have seen this now. I don't know if you've seen it since we got started. Trump nominated Pete Hegseth to be
Yeah, I
defense
saw that.
secretary, a
Yeah,
a serving major in the Army
right,
National Guard, who is now going
right,
to ride herd over a Pentagon full of three, three, four, 3 and 4 star generals.
right. No, I think that's most interesting. Most interesting. Well, do we think, I didn't see the pleading that the Trump lawyers filed, or by New York, they do these crazy letter filings. Did his lawyers argue that on Friday? Not just that it interferes with his transition functions, but that the straight out the supremacy clause means the case must be dismissed.
That's what they've argued. That the supremacy clause, and they point to the law instituting the process as being the federal statute currently applicable that trumps all state laws that conflict with it, including criminal case law, crim, criminal procedural laws as to how he gets sentenced and whatnot. Although,
Okay, so it's kind of a two-step that the transition law cloaks him with enough of the presidency
yes, yes,
pre January 20 that that then invokes the supremacy clause. I mean, that's just those words coming out of my mouth. That sounds like craziness, right? It does. They may be right, but it sounds
I
insane.
think they're right.
Yeah. It's just, did you ever think when you like when you were in law school and all these years practicing law, did you ever think, oh yeah, well, the supremacy clause will make the president immune from any I mean, it's just bizarre in a way. Okay. Well, if that's the argument, then we should see that argument soon in the Georgia case too, right?
Yeah, and I haven't heard a strong argument otherwise either. The the uh, uh, the
The what, King?
the let me think. um, I don't think even Alvin Bragg's team really dispute that the supremacy clause basically at least puts their case on hold. The question is
Right.
how, what process do they use? Is it a suspension or a stay or outright dismissal? Uh,
Right, because that's what Trump's lawyers are asking
yeah.
for is a dismissal of the indictment. It's sort of like you have to come back later and indict him again.
Um, and we're talking about a dismissal under the supremacy clause of the entire case itself, not a
Right.
dismissal based on the immunity issue.
Which just goes to the conviction, so people are clear on that. The immunity argument would overturn the conviction and say you have to reindict him without using immune evidence. But this argument under the supremacy clause is he can't be indicted or tried now from now until he stops serving as president, and maybe you can take a run at indicting him after that.
Correct.
Which leads me to another point, which Ship has alluded to, and which I have made over and over and over again, is that no court has ever said if this process goes into play, whether or not that tolls the statute of limitations or not. If it does not toll the statute of limitations, then you couldn't indict him later because the statute would have run. So presumably it tolls the statute of limitations because, as Ship put it, the person is just legally unavailable to be charged. And why would you count that then against the time period? But no court has ever said that.
Question: does that argue in favor of a something other than a dismissal, such as a stay?
Right.
Because when a case is stayed, uh, the, it, there's no impact on the statute of limitations at all. The case is still pending. It's the but it's stayed. It's kind of halted in its tracks for 4 years. And
And so is the statute of limitations on the criminal side.
correct,
Right.
correct.
Exactly. So maybe that is the same thing. They go hand in hand, but I'm just making the point. No, but no judge has ever, of any level, has ever said that that's the answer. So what's fascinating is we're basing all of this off of just the Constitution itself and OLC's opinion, which isn't binding on anybody other than the Department of Justice. So, well, all right. So let's,
Another question. Uh,
yes.
um, Under the Trump team's theory, that the entire case either gets dismissed or stayed because he's president or about to be president. Uh, does that prevent Judge Mershon from deciding the motion to dismiss?
Well, that's what I was going to ask you next. If that's what we're saying, that the state courts have now been deprived, basically, of the ability to prosecute him, then can Marchand overturn the conviction or not? You know, what can't he do? If their argument is he doesn't have the power to do anything vis-a-vis this defendant, does that mean he can't do anything in that favors the defendant either?
If you want to, if the Trump team wanted to be logically consistent,
Mhm.
they'd have to
You'd
say
have to say yes.
they'd have to say
Right.
yes. He can only dismiss or stay based on the fact that Trump is president elect at the current time.
You can't even rule on our motion to vacate the conviction. Steve's shaking his head. Why not?
If you can dismiss it on the grounds that he's president, why can't you dismiss it on the grounds that tainted evidence was presented and therefore it's got to be a do-over? It's a dismissal one way or the other.
Well, that makes sense if you're not just vacating the conviction and going forward on the same indictment, right? If you're saying also the indictment has to be dismissed, because the Trump lawyers are arguing that the grand jury proceedings were tainted by the immunity also. You follow that, you guys?
Yes.
Right. So Steve's right. If it's an outright dismissal on either, then probably Mershon could do both, right? Or one or the other. But if he were to say, well, I think the trial was tainted, but because there is some law saying it doesn't matter whether you've done things you're not supposed to do in front of the grand jury, it only matters whether you do them in front of the trial jury. If Mershon or the government there were to take the position that the indictment is not tainted and they want him to just order a new trial, then you're right back where we just were, King, right? Of, okay, but can you leave it pending?
You're asking me? I don't know.
Yeah. Nobody knows. Nobody knows. And that's where we are because it's so, some of these questions, that's what I'm saying. Who would even have thought of this, even in law school? Some of these questions are so theoretical, but now we are faced with them because these lunatics engaged in this lawfare and indicted a former president.
Uh,
and and
which
and a, and a future president elect.
Right. Mm-hmm.
now,
Shipping.
one thing that's happening here that we haven't mentioned is that Trump has some really good grounds for appeal,
Yes.
and wherever this goes, short of a sentencing being imposed and a final judgment imposing that sentence, which could be appealed, all of those issues that are lurking in this case that can reasonably be argued make this case a piece of crap in terms of its legal
Is that a
standing.
technical
That
term?
there there are many, many, many grounds that Trump has to get this tossed out on appeal.
Right.
This whole supremacy clause argument that the case can't go anywhere for another 4 years uh, kind of throws a wrench into Trump's ability to go public and say, "Look, the damn thing got dismissed because there was not a real case to begin with. Should never have
Right.
been brought." And here
Or vindicating his
and here
immunity
I've been
claims.
vindicated by a higher court. That's not going to happen for 4 years if the case does get either stayed or dismissed right now.
Right. So let's turn to the federal cases then. So those are clearly going to be, they're going to at least try to dismiss those, right? We talked about this the other night. The 11th Circuit is going to allow the dismissal almost certainly of the appeal of the case in Florida, but a little up in the air whether Judge Chutkan will dismiss the case in D.C., although I think if I had to bet on it, I would say she will. Okay, so same thing. Those, does that mean that they're somehow lurking in the background there until after he's not president again?
Well, let me divert for just a moment to state that I did follow through on my comment from Saturday night when we did that. I filed 16 motions to continue yesterday based on Jack Smith's filing that the election wasn't presented an unprecedented circumstance. So those are now pending before 9 different judges.
Right. I'll be fascinated to see what they do with those. Now, as we said, that it's a slightly different argument than Trump's argument, right? Trump's argument is you can't prosecute me because I'm deputized president now.
Correct, but that's
The
not
defense,
what I was relying on. I'm relying on simply the
right,
acknowledgement by the Department of Justice that the intervening election creates new circumstances that should be taken into consideration in deciding whether these cases should go forward or should be paused pending, developments consistent with the president-elect's campaign statements.
right. I just wanted folks who are listening to know that on January 6th defendants' behalf, you're making a slightly different argument, which is that because President Trump may pardon them, that would be a consequence of the election, that it doesn't really make sense for the court to keep going with the cases between now and when he's inaugurated. So it's not a supremacy clause argument directly, right?
No,
But
essentially it's a conservation of resources in all 3 camps,
right,
and maybe the most. And I'm going to amplify this thing. I'm already getting oppositions filed, but I'm going to, in the reply, I'm going to probably point out or highlight the probation officers.
right,
They're working on pre-sentence reports that might be entirely unnecessary.
Unnecessary, right.
And then, the court staff who's going to have to review those reports, prepare bench memos for the judges, and, the prosecutors who have to write sentencing statements, the defense lawyers have to write sentencing statements. And if none of these sentencings are going to take place, why don't we wait 6 weeks till we know
Right.
whether that's true or not?
Right. It's not like he's going to take office in June, right? It's coming up.
And the only prejudice is mere delay of a matter of weeks.
Right. Which, come on. So, okay, well, yeah, we will be interested to keep us informed as to how that turns out. But, it's interesting to me that I feel like the legal community, us included, Trump's lawyers included, are just kind of coming around to the conclusion that, okay, the legal meaning of Trump having won the election is that certain theoretical things are now made real in the world, right? And because last week, it seems like a long time ago now, but I think it was last week when Jack Smith was like, well, he's going to shut his office case down. Legal commentators were all saying, well, this isn't going to affect the 2 state court cases, or it's unclear if it will, right? And now it seems like people are coalescing around the view that, well, if you really think about it, probably those 2 cases, state court cases, are dead also for the same reason.
Well, I think they're coalescing around the view that it didn't work. So what's the purpose?
Well, yes, those people are, but I'm talking about lawyers and professors and so forth. But people like us.
In a slightly different arena, let me also add this to the reality of the election is very different than the theoretical impact of the election.
Right.
Back to Pete Hegseth. This is from an interview a month ago. somebody's interview said, "How would you correct that?" Well, first of all, who do you have to fire? The answer was, you've got to fire the chairman of the Joint Chiefs and obviously bring in a new Secretary of Defense. But any general that was involved, general, admiral, whatever, that was involved in any of the DEI woke crap, they've got to go.
Right.
That's your new defense secretary.
Right. I know. And he's not going to be the only one, right? This cabinet is going to be full of people whose view is that we have to get back to first principles.
Right, and I don't know if you saw shortly after that, or maybe shortly before it, the president-elect apparently has created a new government department.
Yeah, that came out just as we were starting. How are we pronouncing this? Doge?
The Doge, or I've seen a Doggy, D-O-G-E.
Yeah, Doge, the Department of Government Efficiency, which is a little too Orwellian for me, but I understand it's part of the,
to be headed up by Elon Musk
crypto
and
thing.
Vivek Ramaswamy.
Yes, Vivek Ramaswamy. I always stumble over that.
I don't know. Do non-existent chairman or do non-existent secretaries of non-existent departments have to undergo Senate confirmation?
Right. I know. It's the first thing I thought. Oh my goodness. So, right. I saved his this announcement because I had the same response. Like, whoa, is this gonna be like what is he gonna? How's he gonna staff that up? Where are they gonna sit? He says they're gonna lead the Department of Government Efficiency, which isn't a department. That's not a thing. So really, what they're going to be is special advisor to or counsel to the president, right?
To the president, right?
Yeah.
Here's our list of divisions to eliminate.
Right. Right. Well, I tweeted that out. Most people don't pay any attention like we do to like the structure of the government, right? But if you just even look at the names of the secretaries that are in the cabinet, you'd be like, why do we need all these different ones?
Yeah, yeah. You know, interesting thing about Higgs. I think I know I'm diverting us off the topic, but
It's all right.
you know the criticism that's coming in from the left is, oh, a Fox News host is now Secretary of Defense.
They haven't looked at his resume. He went to Princeton.
Yeah, he's got a Princeton undergrad and Kennedy School of Business masters from Harvard.
Yeah.
As well as combat deployments to Iraq and Afghanistan.
Right, exactly. Right. This guy, he's a nice looking man and has a very affable presentation most of the time, but he's far from being a lightweight. They're going to underestimate him to their peril. You know, just because he has a nice way of putting things doesn't mean he's not tough. I think he must be.
Bringing this back to this case, but not leaving the administration going forward, it occurred to me that whether this case is stayed or dismissed or Trump is sentenced somehow, you know, regardless of what Judge Merchan does, there's another chip to be played by the Trump team after he gets sworn in and gets hold of the DOJ. At that point, the DOJ could, as a matter of policy, do something that the Biden DOJ probably should have done from day one, which was assert federal supremacy with regards to the federal election laws, which preempt the state election law that Trump was convicted under.
Right.
And that's done frequently, where the United States files suit against a state for a judgment declaring and enjoining the state from using its own state laws in conflict with a federal law that preempts the state law.
Well,
that's what happened here, and it could happen again.
Right. This also puts me in mind of another thing that's going on. All these governors saying, oh, well, we're going to basically be the resistance, especially in the issues of immigration, right? We're not going to help them. We're going to do things to prevent the feds from doing all this. Did you guys forget about those cases on the border that the Biden administration took to the Supreme Court? And the Supreme Court said the border states don't have any role in immigration and they have to get the fuck out of the feds' way? Like, you're going to have to eat those precedents now, libs.
Yeah, but the same thing applies to this election law
Right.
crime, uh, uh, which gonna did at the end of the day, the bookkeeping entries that were made were intended, according to the charges, intended to
Interfere with the election.
conceal federal election crimes. That is, to conceal a campaign contribution uh, in connection with the Stormy Daniels hush money.
Right.
That's how they presented it to the jury. And nothing prevents the federal government from filing suit against New York State
Which they would do in federal court.
to to enjoin them from ever using that bogus state law that way now and ever again. What if they win that case?
Right.
What's it
They
do?
win that case while the New York case has stayed while he's president. And now New York really can't bring that case after he leaves office.
Cannot bring the case, cannot pursue the case they've already brought, because basically the federal court would hold that that state law Alvin Bragg is writing on isn't a law at all. It's been preempted by federal law.
Right. Well, that would get rid of the New York case for later, and then that would just leave the Georgia case.
Yeah, there's a couple aspects to the Georgia case you can make the same argument. It's not as clear as the New York case, however, because the New York case specifically ties to
A
the
state election statute purports
federal
to,
elect. Yeah,
yeah,
right. The federal campaign election campaign law.
right, right. So it may be, you guys, that it's sort of a ambiguous result, right? That there's no clear cut, yes, this New York case is thrown out. Yes, it can never be brought again, or it can be brought again, but not until later, or whatever. It it may turn out to be less sort of all tied up in a nice bow than we would ideally like. And there may not be anything that can be done about that until we see how time plays out.
So, what's your prediction will happen?
What do I think Judge Merchan's going to do?
Yes.
I'm not sure I know him well enough to know, but I'm influenced by the fact that he didn't want to interfere with the election before. I think he may say, I think he probably doesn't want to rule on the immunity issue, for many reasons, not the least of which is he's going to have to admit that he screwed up admitting that evidence when they asked him not to in the first place. So I won't be surprised if he actually does what the Trump people ask and he dismisses the case and then lets Alvin Bragg figure out what if anything, he can do with it.
That would be my guess too.
Yeah, I give him very little credit for integrity. I think he is, in the state of New York, he's 100% a Democrat partisan judge because that's how you get to be a judge in the state of New York. They run as, he was appointed, but when he has to run for, election, they run as partisans on a Democrat ticket.
Yeah.
And
But he clearly did that because he was afraid, not that he was actually going to interfere with the election, but he was afraid about how he was going to look if he tried to sentence Trump before the election.
no. My point is my point is that he has revealed, I think, quite clearly political motives behind nearly all of his decision making in the case. Well, what would be his political motive now? It's like he's now engaged in, you know, incredible asymmetric warfare where he's on the losing end.
Right.
And, in the back of his mind, I do not think it is lost upon him that he has a daughter who potentially is exposed to campaign finance investigations. And what is the purpose to be accomplished by continuing to poke this tiger with a sharp pole just as the tiger's cage is about to be opened?
Well, that's what I'm saying. I don't think it's so much politics as it is his own personal interests that are going to
Exactly.
drive him. Yeah.
Exactly.
Right.
And so the case is now tar baby. So you got to get away from it. And I think the easy way from get away from it, and it's defensible in this sense. Yes, the Trump defense tried to keep certain evidence out on a claim of immunity that had never been recognized by the Supreme Court. And so I think he could defensively say, I let that evidence in. Probably the best thing to have done at the time would have been to simply wait 8 weeks until the decision was made by the Supreme Court. Then I would have had that guidance, but I didn't.
Right.
We went forward along the schedule that had been set. There was no controlling legal authority that directed me to keep that evidence out. So it came in. Now, clearly, based on the Supreme Court's decision, it shouldn't have come in. The case was contaminated by significant evidence that the jury should have not heard. Therefore, I have to vacate the verdicts. And because he's now taking office, we're going to dismiss the case on the basis of, supremacy clause, and he's unavailable. And we'll revisit the matter in 2028 if the district attorney at that time desires to do so.
Right. Right. Over back to you, Alvin. But meanwhile, you're out of my courtroom. Thank you and goodbye.
I have no, state of New York versus Trump any longer on my docket.
Right.
Please leave me alone. Don't call. Don't.
Right. Lose my number. Right. Yeah, that is what I think he'll do because he, like us, has to think through all of these issues and how they all bounce off of each other. But he's going to do what he thinks is in his best interest. And I agree with you about his daughter. I don't know whether he thinks that's a live round or not, but assuming that plays some part, what he's going to do Alvin Bragg's work for him, I think those days are over.
Did that. He carried Bragg as far as he could.
Right.
And there's no good purpose served for going forward.
Right. So, will the judge in Georgia be faced with these same? See, I'm intrigued by this. If you're Trump's lawyers, I mean, you must just be working 24/7. There's just so much to do, right? Presumably, we'll see a motion in that case, although it's stayed now, right? It's in the state court by virtue
Yeah.
of the appeal.
Yeah, you've got the issue of whether Bonnie Willis will stay on the case. That's one.
Now,
But
King,
the
let
other
me
thing
ask you
is,
that's staying the case at the request of a different defendant, right? Not Trump directly.
well, he's involved in that appeal, that motion to disqualify her. Yes.
Right. I mean, they
Uh,
all are, but another defendant's lawyers is sort of the lead on that, right? Trump's
Correct.
saying me too. Yeah.
Yes. But once that's resolved, then either the case with Fonnie Willis leading it or some other substitute prosecutor put in charge, uh, then you've got that issue
Then yeah,
as to President Trump.
right. Then it'll
But
surface and we'll see that motion again, right? Yeah.
except you've got all the other defendants in that case, the other 17, 18 remaining defendants who don't have that defense. They can't. The case, technically can proceed against them too.
You know what Trump should do? He should hire them all into the administration and then they can all ask to remove again on the basis that they're currently federal officers.
They're all, employed as White House staff.
Right. That's if I were Trump, that's exactly what I would do.
They're on 60-day contracts.
There you go.
But
Now they're
as to
current officers,
yeah,
not former.
as to Trump, he gets out of that case the same way he gets out of the New York case. Uh, there are things he can do with his DOJ in that case to at least launch an investigation of whether federal uh, there were federal crimes committed by the prosecutors.
Which ones now are we talking about? Fannie and Friends?
Yes.
Yeah.
So uh, he could turn his DOJ on the offense against the prosecutors in that case. They may not want to see it to the end either.
Well, I wonder about that. So, are we talking about sort of like a conspiracy?
Yeah, the again the things like what they did to Jeff Clark
Yeah.
is in my view uh, went way beyond the pale.
Oh, I agree. It's obscene. I'm just not sure what federal criminal statute it violates.
I'm sure there will be people looking.
Yeah, I think there will be because there's been a lot of calls since last week's election from all kinds of voices on the right saying that we want accountability and we want something done about this lawfare and we want these people to have to um, be held to account. And I agree with that. I wonder though if the criminal law is set up to provide criminal accountability for very many of them. But we'll see. I'm sure
Right
we'll
now,
be talking about that going
I'm not
forward.
aware of any, uh, but there will be investigations, just like Congress has already begun some of those.
Yeah, well, the Congress should just go to town on it for sure. And DOJ certainly could do, if not investigations of that kind, the OIG or DOJ management, new OIG, could do a review of that and say, okay, here's where we went wrong on all of this, right? Um, and formulate new policies and procedures. I think that a lot of the right won't be happy in the end, likely, with the kind and quality of accountability that is available under the law. And I know people get frustrated with that, but what I often tell people is the reason we don't have laws that apply to this is because we don't do this. We don't prosecute the former president. We don't prosecute the former administration, right? This is a deviation from our norms and our laws. And that's why we don't have statutes on the books already to prevent this. Maybe we need them now, God help us. But the people say, well, how can the law not cover that? And I think the answer is because our norms were keeping us from doing this before. We didn't need laws to do so.
Actually, you had laws that the legal teams in the Georgia case and the Arizona case thought they were following. Or they were going to court. They were asking for relief in court. They thought they had evidence that plausibly uh, uh, indicated some illegality or irregularity in the election
Well, I
that
wasn't just
they
really
gave
talking
them a
even
right to
about,
relief.
yes, but I wasn't really talking about the election integrity. I was talking about the lawfare, the lawsuits, the criminal
I know,
prosecutions,
but
the Russia hoax, all of
but
that.
in this particular case, the Georgia case, the Arizona case, both are brought. Criminal charges are brought against legislators, lawyers, uh, and others in the associated with the campaign who were following the book in terms of how you contest an election. And And the whole thing kind of is, from a trial lawyer's perspective, is offensive.
Right. Oh, I agree. I agree. I just want to, let people know, is James Comey going to be dragged off to jail? The answer is no. Right? Notwithstanding what he did to Carter, notwithstanding what he did to General Flynn. So, it's there needs to be accountability, and I think we are going to see some, but it's not going to be the same thing done to them as was done to these folks: Meadows, Clark, Trump, Bannon,
You know,
Navarro. Those two prosecutions are obscene. It's just not going to happen.
well, back to New York, the one thing I can reasonably uh, predict, if that is, if Trump's DOJ is inclined, they have a pretty good case on the preemption
Yeah,
issue.
they do.
And if they win that, that puts the New York case, no matter how it's disposed of right now, it forever puts that case to bed.
Right. So, there's various procedural ways, but this supremacy clause cutting in here at this juncture just makes the whole thing more difficult. Now, more fascinating for lawyers, but more difficult, I think, for the judges to grapple with. So, well, we've been going for a couple of hours here. I didn't think we'd go so long on this, but we did also fit in Ship's experience today with one of his J6 cases. So I hope you guys enjoyed all of that. And either one of you have anything you want to wrap up? King, do you have an anecdote?
Not today.
All right.
No,
Well, my friend, you need to work
I,
on your repertoire there.
I do. I I had a medical emergency, not me, but somebody in the family had to
Yeah.
tend to this morning, so didn't get any sleep. So
Right.
uh, I will do better next time.
All right.
All
Well,
right,
I'm just
time to
pulling your
go.
leg, my friend. Good night, guys. Bye.